Our next chapter is going to address liability under state tort law. And this is a very, very important topic because many cases have evolved defining the law enforcement agency's liability under tort law. Tort law is generally state law. We have federal laws and state laws, and this is an area primarily state, on state levels. Before we jump into it, I just wanted to repeat that these online video lectures are not supposed to replace your book. You should always read the materials in your book and the handout materials. These online lectures are really a supplement to those materials to give you a well-rounded learning experience. There's no way to avoid reading. When you study the law, you have to read, especially reading case precedent. Stare decisis, let the case stand. Now, there's no better way for officers, a department, or police executives to insulate themselves from threat of civil liability than to have a good understanding of the framework of liability law. And that's exactly what the purpose of this online video lecture is meant to do. Now, let's first start out and define the difference between a tort and a crime. At one time, they were the same, but over the years, they evolved to be two separate categories. A crime is a criminal act. The government is the plaintiff, whether it's a state or federal level. The plaintiff in the litigation is the state attorney or the attorney general. And generally, they have to prove their case beyond a reasonable doubt. And the sanctions they're seeking are monetary in nature, fines, penalties, revocation of licenses, are generally jail time. Torts, on the other hand, are private wrongs. They are private lawsuits in which individuals sue each other. Governments can be involved, government agencies can be involved, but generally they are not seeking criminal sanctions, such as loss of liberty, jail time. In tort cases, the standard or burden of proof is carried by the plaintiff, and they must prove all elements of their claim by preponderance of the evidence. So when an individual sues another individual, that is generally based on a tort claim. It is a private claim. Law enforcement agencies can be sued and often are defendants in tort claims. Now, can a crime and a tort be the same? The same actions spawn those types of lawsuits? Yes, the answer is yes. For example, in the O.J. Simpson case, he was criminally charged for murder of two individuals, and the saga played on TV. And if you recall, there was evidence produced by the prosecutor, the prosecution team, headed up by Marcia Clark. And you saw the glove that didn't fit, the hat, evidence of the dog barking at night, DNA evidence, blood evidence, the slow-moving chase in the Bronco. All of this was put before a jury, and the Dream Team defended. And they prevailed because the government, the prosecutors, could not prove their case beyond a reasonable doubt. The evidence just did not reach that level, at least in the minds of that jury. However, the same act spawned a civil lawsuit by the family members against O.J. Simpson. The two decedents the victims. Their estates were opened up, personal representatives were appointed, and they sued on behalf of the estate for the tort of wrongful death. And there, the jury heard the same evidence. The glove that didn't fit, the slow-moving chase of the Bronco, the blood in the Bronco, the DNA evidence, the cap or the hat, the dog barking, and that jury found O.J. Simpson liable because the evidence did rise to the level of preponderance of the evidence in their minds. Now, a party to a lawsuit generally are the plaintiffs and the defendants in a tort claim. There can be third parties brought in through cross claims, or there could be a counterclaim, a defendant counterclaims against the plaintiff. But generally, when tort claims are filed, the defendants are the line office, road officers or deputy, the supervisor, the sheriff, or the chief of the agency. They're all named in certain capacities as defendants. Now, there has been, over the years, a rise in a number of lawsuits against law enforcement agencies. Whether this is a real or frivolous or nuisance or deep pocket lawsuits is open to debate. Some feel that attorneys are over aggressively marketing themselves for tort claims. And you hear of these frivolous lawsuits on TV. But keep in mind that our litigation system is a legitimate mechanism of social control over police power. And so they do continue to allow these claims to exist. The dollar amounts awarded seem to increase year after year. So law enforcement agencies need to be sensitive to this area of liability. Most lawsuits, tort claims, involve assault, battery, false arrest, false imprisonment, invasion of privacy, and intentional infliction of emotional distress. We'll get to each of these individual tort claims shortly, but that is a list of intentional torts. Intentional torts, because the actor, i.e. the law enforcement officer or the deputy, meant to do it. It wasn't an accident, they meant to do it. Now let's start with some good news. The good news is that there are certain immunities granted to government agencies, including law enforcement agencies. And here are the three major ones here on the screen. There's sovereign immunity, there's qualified immunity, and then there's absolute immunity. Absolute immunity is rare, but it does exist with certain public officials, such as judges and prosecutors. They generally are immune from a lawsuit by defendants. Absolutely. If you think about it, nobody would ever be a judge or a prosecutor because they'd be constantly sued for their wrong decisions or their discretionary acts or their overzealous attempts at getting a conviction or enforcing a remedy. So absolute immunity rarely exists, but it does exist for prosecutors and judges. Qualified immunity. Qualified immunity is limited immunity. It may or may not cover the officer or deputies or law enforcement actors' conduct. It may relieve them of liability, protect and insulate them from liability. That's why it's not called absolute, it's qualified, because it depends on the certain cases and certain facts that allow it to kick in. And we'll get to that in a minute. But let's first turn our attention to sovereign immunity. Sovereign immunity is a very old traditional defense. It arose from common law back in England. We had kings and queens back then. And the concept was that the king and queen could never do any wrong. They were descendants from God. Their decisions were always correct. They could never do wrong, and so thus you could never sue them. They were a sovereign and immune from a lawsuit. It was good to be king back then. Well, we, as a common law country, former 13 colonies of Great Britain, adopted their legal system and this principle. However, it mutated and changed over time. We eventually became our own country. We got rid of the king and queen. We had government agencies, and we adopted this thing called sovereign immunity. However, not from the perspective that our governing authority, i.e. our government, was always right. In fact, we perceive our government always getting it wrong. It can be challenged. Our government is made up of people, and people are not perfect. So sovereign immunity really mutated in our system to protect government agencies, not just law enforcement agencies, but government agencies in general, from lawsuits. Now, some sovereign immunity statutes, which are, and by the way, these are all statutorily granted in each state. Some are absolute, meaning you can never sue, but those are rare. Most statutes open the door to negligence to a certain degree, or allow a claim against the agency to a certain degree, a monetary limit. For example, in 1975, the Florida legislature passed 768.28, which allowed for lawsuits to proceed against government agencies, including law enforcement agencies, but limited the damages that could be recovered. The reason why is because our government generally can get things wrong. And if we allowed our government to be sued for unlimited damages or true damages it causes, we would go broke. The government would go bankrupt within a year. Every law enforcement agency would go bankrupt within a year because mistakes happen. Valid mistakes happen. Intentional torts are purposeful, and so we have some wrongdoers in the force. And the bottom line is we need sovereign immunity to prevent our government entities, not just law enforcement agencies, but government entities from going bankrupt. So Florida statute, let's just take an example here because each state is a little different. Each state has its own sovereign immunity statute. Florida statute 768.28 waives sovereign immunity, but to the extent of about $200,000 per claim, and under some circumstances, $300,000. So in Florida, you can sue a government agency for a tort up to a certain level or amount. Now again, sovereign immunity only applies to government entities. It doesn't apply to private entities. There are some theories of cloaking private entities with sovereign immunity if they act on behalf of the government, such as private police forces. They're generally private for-profit corporations. Can they be sued? Should they? Yes. The answer is obviously yes. Should they be entitled to sovereign immunity rights so that they don't go bankrupt? There's a big debate about that. Some people say, hey, if they're in it for profit, then they're in it for loss as well. My perspective is that only government entities should have sovereign immunity because we, the people, control them. We don't want them to go bankrupt. But if it's a business that does wrong, then they should be held accountable to the full extent of the law, regardless if it's privatization of prisons or privatization of police forces. I'm not a big fan of either or, but I can see why they are generally a movement towards those industries. Now, sovereign immunity has some exceptions, and in Florida law, in the same statute, Section 9A, has some exclusions. If the omission or act, which is the subject matter of the lawsuit, was done in bad faith or with malicious purpose or in a manner exhibiting wanton or willful disregard of human rights, safety, or property, there can be tort liability. So it prevents most torts. But if it falls in this category, then torts can occur and the recovery can be limited to $200,000. Qualified immunity generally applies to individuals who are working for government agencies, and in our case, law enforcement agencies. It only applies to lawsuits against government officials as individuals, not lawsuits against government agencies for damages caused by officials' actions. It is an immunity for having to go through a trial at all. In other words, it's one of those defenses that rears its head immediately in lawsuits. Defense attorneys who are defending police officers or deputies in litigation, in tort claims, will raise it immediately. And therefore, courts generally must address this issue right away. Qualified immunity is a balancing test. It balances two interests: the need to hold the public officials accountable when they exercise their power irresponsibly versus the need to shield officials from harassment, distraction, and liability when they perform the duties reasonably. So if they act reasonably, qualified immunity protects the officer, the deputy, the law enforcement personnel from liability of tort claims. However, if they exercise their power irresponsibly, then qualified immunity will not stop the lawsuit against them. The defense of qualified immunity completely protects government officials performing discretionary functions from being sued in their individual capacities unless their conduct violates clearly established statutory or constitutional rights which a reasonable person would have known. This is all from case precedent, these quotes. Notice discretionary functions. Generally, if a deputy or a law enforcement officer is sued because of a discretionary act, they decided not to rush into the shopping mall and wait for backup for the SWAT team. Generally, that's a discretionary decision. They can't be sued later by those that are injured. However, if they violate clearly established statutory or constitutional rights which a reasonable person would have known about, they can be sued. For example, if a law enforcement officer uses drones. In Florida, we actually have a statute that limits the use of drones by law enforcement. And let's say a law enforcement officer or deputy uses a drone to peek in somebody's window on the 7th floor of an apartment building. And the drone is hovering, and they don't have a warrant, and there's no emergency, and clearly the use of the drone is not allowed under this statute. Then that deputy, by peering in, is a peeping Tom. They're violating a known statutory right of privacy, which a reasonable deputy or road officer would have known, and therefore qualified immunity will not work when they're sued for violation of privacy. Discretionary functions, that's the key. Government official must prove he or she was acting within the discretionary authority. Courts assess whether officials' acts are within the official's duties and within the scope of official's authority. The burden then shifts to the plaintiff to prove that there was a clearly established constitutional right and whether the reasonable official would have been awarded. So it's kind of a shifting of burdens here in the lawsuit that will occur. Now let's talk about state lawsuits, specifically torts. It is everybody's right to sue. Believe it or not, in our Constitution, we have a right to sue. It's due process. It is within the rights of all citizens to take legal action against persons or government agencies whom they feel have been wronged. A civil tort is a private injury inflicted on the person by another. Tort Claims Act passed by all states and Congress to make government more accountable and compensate citizens injured by government actions and employees. There are three classifications, if you will, of torts, or three categories. There's intentional torts, which are often targeted at government agencies, especially law enforcement, corrections agencies, or law enforcement agencies, and they're used in police cases. We'll get to them in a minute. Then there's the big category of negligence. That's accidental. Again, police and law enforcement agencies are often defendants in negligence cases. They're used in police cases. And then there's a third category, which generally is not used in police cases, are generally law enforcement agencies, sheriffs, departments are not defendants in, called strict liability tort. Strict liability tort is based on the premise that there is conduct or activities that are so inherently dangerous that if something goes wrong, you're automatically liable as a defendant. If you participate in inherently dangerous conduct, you're automatically liable for any injuries that occur or stem from that. Strict liability is very prevalent in the private sector. Businesses get sued for strict liability. Let's say if you run a nuclear power plant, if something goes wrong, you're strictly liable because that is a risky business, assuming the damage occurs from a leak of nuclear material or something along those lines. But strict liability generally is not allowable against law enforcement agencies. Even though they participate in inherently dangerous activities, catching criminals, catching the bad guys, it doesn't apply. The only exceptions are every now and then you see militarization of police forces. If they use tanks, armored vehicles on the roadway, those are inherently dangerous, and if they crush a car by accident, that's a problem. They should have known. It comes part and parcel with the activity. It's a risky activity. Our drug raids with the use of a tank or armored vehicles. So generally, though, strict liability tort doesn't apply. So let's move into these areas in that order. Intentional torts. Deliberate indifference, which is a key phrase often used in litigation against law enforcement agencies. Plaintiffs love to prove deliberate indifference by the defendant, i.e. the road officer, the law enforcement agent, or the sheriff or the deputy. Deliberate indifference to a legally recognized interests such as rights to bodily integrity, emotional tranquility, domain over property, and freedom from confinement. These interests are violated by intentional torts of assault, battery, trespass, false imprisonment, invasion of privacy, and intentional infliction of emotional distress. The intent element is satisfied when the tortfeasor, the actor, acts with the desire to bring about consequences and is substantially certain the consequences will follow. Now let's talk about some specific intentional torts. We call them intentional torts because the actor, the defendant, meant to do it, assuming that the allegations are proven in court. So if the officer, the road deputy, the law enforcement personnel meant to do it, there was a desire and intent to do it, and they did it, it would fall in this category. Now, false arrest and false imprisonment are slightly different, but generally the same. There's an intent to arrest or take into custody, and the key defense, though, here is probable cause. If an officer just arrests somebody on made-up charges, fake charges, that would be false arrest or false imprisonment. The key defense here is probable cause. What that means is that if the police officer or deputy or sheriff's deputy or law enforcement official can articulate probable cause for the arrest, even though a conviction doesn't occur, it can't be false arrest. A lot of people get this wrong. A lot of citizens believe that just because they fought the charge in court and they prevailed, remember, in criminal court, it's beyond a reasonable doubt. And let's say the prosecutors can't prove that, or the prosecutors drop the case, or the prosecutors plead out the case. Then they turn around and sue for false arrest or false imprisonment. An affirmative defense, and what we call that affirmative defense means that the defendant, i.e. the law enforcement agency or personnel, they have an affirmative defense of probable cause. If they can articulate probable cause, then hey, they can't be sued for false arrest or false imprisonment, even though the charges never stuck. Assault battery. Assault is the intentional causing of apprehension of harmful or offensive conduct. It is an attempt or threat accompanied by the ability to inflict bodily harm on another person, committed if a deputy causes another person to think he or she will be subjected to harmful or offensive contact. So it's a threat, a meaningful threat, one in which there's an ability to carry it out, to put someone in fear or apprehension of immediate harm. If deputies or officers threaten someone when they have no basis for it, that could be a tort of assault. Battery is the harmful or offensive touching, the intentional infliction of harmful or offensive bodily contact. Given this broad definition, the potential for battery exists every time a deputy applies force on a suspect or arrestee, assuming that if they're acting in an unlawful manner, the deputy or law enforcement officer, they don't have a lawful duty to act, then they could be held liable for battery. It's an intentional tort. And keep in mind, when a law enforcement officer sued, then generally it's the whole chain of command in the agency itself. Lots of defendants are added to the mix because they knew or should have known, or failure to train, or under the theory called respondent superior. That's Latin for let the master respond. Respondent superior is when an employee or agent of any entity or business does something wrong on the clock while doing their job. It exposes the principal, i.e. the employer, to automatic liability. So when we talk about intentional torts, it's not just the road officer that is out there on the limb as a defendant. It's generally everybody, the agency itself. Other intentional torts: violation of privacy, intrusion into seclusion of someone's private affairs, trespass and nuisance. Trespass generally is a physical, unlawful entrance into someone's land or property, whereas nuisance is a unreasonable interference with someone's right or use of property. Intentional infliction of emotional distress. This is conduct that goes beyond all decency, beyond society values, over the top bad. You meant to hurt someone through your words and conduct. Road officers, law enforcement officers can be sued for all of these, assuming that there is no probable cause and there's no lawful duty that they're exercising. They're acting beyond the scope and authority of their position. False imprisonment and false arrest we talked about. Wrongful death and excessive use of force. These are related charges that are bases for torts. False light, similar to violation of privacy, but it's when someone's image is cast in the wrong light. This often are the types of situations where you have reality TV shows where officers are barging into people's houses and maybe it's the wrong house. Or they accuse someone without probable cause of doing a crime on camera. That could be, and then it's filmed and videotaped and distributed. That's a false light. It's also defamation. Defamation is an intentional tort. Defamation comes in two types: libel, L-I-B-E-L, and slander. Slander is spoken, libel is written, but they're both defamation. All defamation claims must be proven by a plaintiff by preponderance of the evidence. There are three elements to prove defamation. An untruth is told. It's communicated to a third party, and finally damages occur. Let's say, for example, a road deputy or law enforcement officer tells a shopkeeper that a lady shopping in the Quick Mart is a prostitute. Now, let's assume the deputy or police officer knows that this individual is not a prostitute. In fact, he's trying to get back revenge. It's a ex-lover, ex-girlfriend. And he tells the shopkeep, oh, that person, she's a prostitute. Keep an eye on her. Notice there's an untruth told, it's communicated to a third party, and finally damages occur. If of loss of reputation, or if that shopkeeper kicks her out, or maybe rumors are spread because of that and she loses her job. The untruth is told, it's communicated to a third party. Communication can be unpurposeful or accidental, but the road officer communicated to a third party. And finally, damages occur. Now, there is a thing called per se defamation, which the example I gave you is actually per se. That's over the top bad. Not only is it an untruth, but it's a really, really bad untruth. If you accuse someone of sexual promiscuity or being a criminal or having a contagious disease, that generally is over the top bad. It's per se. And the defendant who is sued for per se, it's a very serious matter. And a plaintiff only has to prove that the untruth is told and it's communicated to a third party. They don't have to worry about proving damages. Damages is sometimes hard to prove. But in a per se action, you do not have to prove it as a plaintiff. It's presumed. The untruth, the lie is so bad, over the top bad, that the court presumes there's damages. Keep in mind, the scary part of all of these intentional torts is the fact that they carry punitive damages. When you sue somebody in a lawsuit, generally you recover compensatory damages. Compensatory damages are those damages to make you whole, put you as a plaintiff back in a position as if before the wrong occurred to you. Compensatory damages are generally monetary damages, but could be other types of damages, to put you in a position before the adverse act against you. It could be lost wages, it could be pain and suffering, it could be medical bills, loss of savings, whatever it may be. Those are all compensatory damages. Generally, all lawsuits you can sue for compensatory damages. Breach of contract actions, family law, divorces, what have you. However, there are certain types of lawsuits that allow for punitive damages. Punitive damages are much worse. They're over the top amount of money, beyond compensatory damages. You get your compensatory damages, but then punitive damages are given to the plaintiff by the judge or the jury to punish the other party, to hold them out as an example to society of what not to do. Punitive damages could be $1, or could be $10 million, or even higher, $34 million, to show society that individuals, government employees, law enforcement agencies, law enforcement members should not be doing things, and they should be punished for this so that nobody does it again. So intentional torts are very serious because they carry punitive damages over the top of compensatory damages. The other type of tort is negligence. Negligence is accidental. All law enforcement agencies are made up of people, and people make mistakes. And so we are responsible for our mistakes, but only up to compensatory damage levels, not punitive damage levels. And negligence, there is no intent, it's accidental. The injury is caused by a careless act or failure to perform a legal duty. Key defense in law enforcement type cases is the reasonableness of the defendant under the situation. If the defendant, i.e. the road officer or police officer, acted reasonably, generally, they satisfy the legal duty of care, and they didn't breach that. Let's go into the 4 elements of negligence, because there's 4 elements. Remember, negligence tort is a non-intentional tort. People can be sued for negligence. Businesses can be sued for negligence. Government agencies can be sued for negligence, including law enforcement agencies can be sued for negligence. There are 4 elements that a plaintiff must prove by preponderance of the evidence. Remember, that's the civil standard. There must be a legal duty owed by one party to another. There must be a breach of that duty of care. There must be a proximate cause between the breach and the injury. And finally, damages occur. So we go through these. Let's go through them one by one, but it's duty, breach, causation, damages. Duty, breach, causation, damages. A plaintiff, not the defendant, but the plaintiff must prove all 4 of these elements to prevail. So let's walk through these 4 elements with a typical example that I see all the time. Negligence operation of a motor vehicle by a deputy or a police officer. There's a lot of things going on in the marked unit or the unmarked patrol unit. There is radar detection equipment. There is radios in the consoles, or even radios on the deputies or police officers themselves, mobile radios. There are cell phones, text messaging. There are open laptops which have CADs, computer-aided dispatch systems, and sounds blinking and beeping. And then if you operate your emergency lights, sounds inside the cabin occur. There's the radio, regular music radio. The list goes on and on and on of different distractions, and I see this every day. Deputies are either texting or on one of these devices or using one of these devices, and they're distracted, and boom, they run into another vehicle. Accidentally. They don't do it on purpose, but they accidentally do it. Is the agency liable? Yes. Let's go over the elements. Duty. Is there a breach of duty? Actually, is there a duty owed by a law enforcement officer driving a marked unit to other drivers, to pedestrians, even to passengers in their own vehicles, ride-alongs, individuals riding along with the deputy? The answer clearly is yes. All drivers owe a legal duty of care to other drivers. Did they breach that duty of care? Well, if you're texting while driving, not only is it usually an infraction against the law, it is a violation of the legal duty owed. There's a breach of that legal duty. You shouldn't have done it. The next element, causation. Now, causation can either be actual or proximate. Actual means there's a direct correlation between the breach of duty and the damages. Here in this case, in my scenario where a police officer is not paying attention, maybe checking the CAD and runs back ends into a vehicle that stopped at a red light, there is actual causation. Whereas proximate causation may be the officer makes a U-turn and everyone slams on their brakes, and the officer doesn't use their emergency lights, so they suddenly made a U-turn, and the oncoming traffic slammed on their brakes in time. They avoided a collision. However, 3 vehicles back collides into one of the vehicles. That's a proximate cause. In other words, 3 vehicles back, indirectly, the officer's conduct caused that crash. Damages occur. There's physical damage, loss of money, loss of property. Damages come in all shapes and forms. So in my scenario, yes, all 4 elements are met. Duty, breach, causation, damages. Negligence, though, can be on all kinds of levels. There's all kinds of twists to this type of cause of action against law enforcement agencies. There's the negligent failure to protect the public, maybe in an instance. Maybe there's the negligent failure to arrest. You knew of a fleeing felon, you just turned the other way, and that fleeing felon then causes someone else's harm. You may be sued for negligence, failure to arrest, when you had the ability. Our DUI suspects, we're going to get to that shortly. They're driving under the influence. It's clear that they're drunk. They can't even stand up. In a roadside sobriety test, they fail miserably. And they blow, a .90. But you allow them to drive home. That might be a negligent failure to arrest if that DUI driver crashes into someone later. Negligent failure to protect is an example where the officer fails to rush in when he hears gunshots. Now, that's a really probably a qualified immunity type situation that's going to protect the officer. But let's say that there's clearly a policy and procedure to rush in. And by the way, that's the new training of these mass shootings, is not to wait for backup. It's to go ahead and move into the zone as quickly as possible. So there is some policies and procedures mounting that's the standard now, rather than waiting for the SWAT team, rather than containing the threat. The theory is to move in and neutralize the threat ASAP. But anyway, negligent failure to render assistance might be a type of negligence. Premises liability for law enforcement facilities. If the facility itself is dangerous, let's say that the guardrail or handrail on the stairs is always shaking and about ready to fall off, and then you're escorting a prisoner up the steps, and the prisoner grabs the handrail and the handrail breaks. Notice in my scenario, it breaks because it's defective, not that the prisoner's trying to escape or used extraordinary leverage or leaning on it. They just grabbed it for stability purposes, like guardrails are meant to be used for, and it breaks and they fall down the steps. That could be premises liability. Duty, breach, causation, damages. Negligent selection and hiring and training of officers. If you fail to do background checks, that could be a problem. Failure to train, failure to supervise is another type of negligence. Negligent entrustment. Let's say that you give out automatic weapons, rifles to your officers, but you don't train them. That's a problem in the use of that specific firearm. Negligent failure to discipline or investigate. You're put on notice that there are problem apples, bad apples in the workplace, and you just turn a blind eye. You move them about from station to substation, transfer them constantly, but you never remedy the problem, never discipline them, or never remediate or retrain them. That could be a basis for negligent failure to discipline or investigate. Notice all of those themes are based on negligence. Duty, breach, causation, damages. In a different context. Now, there's a public duty doctrine, which basically eliminates the general duty owed to the general public. Governmental functions such as police protection are owed to the general public and not to specific individuals. So therefore, that duty element in negligence really has to be specific to a plaintiff. The law enforcement officer, the deputy, must owe a specific duty of care. For example, let's say you own a shop, shoe store, and at night it gets broken into, and you lose all of your inventory. Can you sue the individual officer on patrol that night for failure to do a good job? The answer is no, under the public duty doctrine, which is really a defense. There's no specific duty owed by that deputy to that business. The duty is owed to the general public to patrol, but not to that specific individual. So the duty element is not met. The public duty doctrine eliminates these large duty doctrines or duty obligations by law enforcement to specific individuals. However, if there's a specific duty owed to the shopkeeper, to the shoe store owner, let's say that the shoe store owner hires a off-duty detail, one of those private security details in which law enforcement officers on their own time are contracted out in uniform to stand outside the premises at night, specifically paid for by that shopkeep. And that deputy goes to sleep in their vehicle late at night. They breach the duty of care if that place is robbed. They're sleeping in the back parking lot in their own marked unit. That would be not a public duty doctrine prevention. In fact, there is a special duty relationship that exists through contract, and therefore there is negligence there. The deputy or officer went to sleep. Now, in all of the cases dealing with negligence, there's another couple defenses that I need to bring your attention to. The first one's called contributory negligence. Contributory negligence is a situation in which the plaintiff, the one suing, is partially to blame for the mess. They're partially to blame for their own damages. They acted negligently or improperly. Under contributory negligence defenses, if the defendant can prove the plaintiff acted improperly and is partially to blame for this mess, partially to blame for their own damages, then they're prevented from suing. In other words, the plaintiff loses. Now, there's only a minority of states that adopt contributory negligence. I think there's only 5 states out there. Most states adopt the comparative negligence defense. And keep in mind, both of these are defenses to negligence cases. Comparative negligence defense says that the jury can take in consideration the percentage of blame by the plaintiff. The plaintiff is the one suing the law enforcement agency or the law enforcement individual, officer or agent or deputy, for negligence. And the defense is that the plaintiff is partially to blame for their own losses. They acted negligently. They didn't act with due care. They're partially to blame. The percentage of blame attributable to the plaintiff offsets in proportion their monetary recovery. So in other words, if the defendant can prove the plaintiff is 30% to blame for the mess, for the problem or the instance, or 30% to blame for the plaintiff's own damages they suffered, then their monetary award given to them in the lawsuit is reduced by 30%. So comparative negligence is like a sliding scale defense. Whatever the percentage to blame that the plaintiff is responsible for, their monetary award is offset or reduced in proportion to that percentage. Now, some states that adopt comparative negligence do a hybrid, and they say, listen, if there's evidence that the defendant produces that shows the plaintiff is more than 50% to blame, they get nothing. Some states adopt that approach as well. So there's contributory negligence, which basically bars the action if the plaintiff is 1% or more to blame, and comparative negligence, which reduces the plaintiff's recovery in proportion to their blame. Other defenses to negligence are waivers, but all waivers, first of all, must be in writing generally, and they must be voluntary and knowingly. The person signing the waiver must be informed of or know of the risks, and they voluntarily sign the waiver. Often this is the case with police ride-alongs or different programs in which youth camps, in which police athletic league programs offer students activities after school. Well, they get waivers signed by the parents, of course, because children can't waive rights. However, if the waivers are written in such a way as to absolve the actor from all possible conduct, even intentional conduct, intentional torts, they're generally voided as against public policy. We don't want to give a license to someone to hurt people and not be able to be sued for the hurt they cause. Waivers are a defense to negligence. Assumption of the risk is a defense to negligence. If people participate in inherently dangerous activities, they assume the risk. They can't sue later for such actions. Sovereign immunity, we talked about, is a defense to negligence. Qualified immunity is a defense to negligence. Absolute immunity generally is a defense, obviously, to negligence. And sudden peril is a theory and also a defense to negligence. That means that suddenly the officer is confronted with a peril, a situation that they didn't cause. It's an emergency situation and they have to act quickly and make a decisive decision. You can't sit in the armchair Monday morning quarterbacking and sue and claim that the decision was improper. The sudden peril defense often is a valid defense for law enforcement agencies, public safety agencies, fire rescue, etc. Strict liability. We talked about how that is generally not applicable to law enforcement agencies. It's a theory where a business or person participates in inherently dangerous activities and therefore they are strictly liable, automatically liable. Them and their employers are automatically liable for the damages that result. That is generally not used against law enforcement agencies. However, sometimes it is. If they participate in military-style drug raids and someone is injured, or they use military grade equipment, tanks, armored vehicles, and someone is injured. So with the advent or the increasing militarization of police forces, strict liability may be a theory that grows in legitimacy and popularity against law enforcement agencies over time. We will see. I guess the moral to the story of this particular lecture and this theme is to manage risk not only through good training and good policies and procedures, and to take remedial action when you see an employee acting recklessly or with deliberate indifference, or an unskilled worker out there in the workplace, retrain them, retool them. But to get insurance, just like private businesses, insurance is available for law enforcement agencies. They're relatively very expensive policies, but they can protect an agency from liability if you can afford it. These policies vary in size and scope and conditions. Some policies kick in after, let's say, $50,000. The first $50,000 is the agency's responsibility, and then the rest get kicked in, or the first 100,000 is the agency's responsibility, and then the insurance kicks in. Or some insurance policies only kick in and say, listen, we'll cover you for the first $1 million, the rest is your problem. Try to get it if you can. Legal advisors would tell you, get it for police agencies, if it's available. For corrections agencies, if it's available. That's a big if. If your agency is accredited, generally you get better rates on these policies. If your agency has a good track record of not being sued as much, generally, these policies are cheaper. But these policies have a lot of strings attached, a lot of exclusions. They don't cover certain things, and they require you to keep up your accreditation or training manuals and training schedules, etc. Premiums are very, very expensive. But if it's available, you should get it. Okay, I hope that this is a good overview of state tort law, and it demystifies some of the questions you had in this area of why and how law enforcement agencies are sued under state tort law.